Good morning and welcome. Thanks to all of you for joining us for today's Fundamentals in Healthcare Law webinar focused on HIPAA privacy and security. We've got a lot to go through today, so we're going to get things rolling. Thanks again so much for joining us. This is our 5th of 12 webinars in our Fundamentals of Healthcare Law series. Our next webinar is scheduled for Wednesday, February 16th from 8:30 to 9:30 a.m., and it will focus on licensing and privileging. My name is Jason Castor, and I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome all of you to today's presentation. Thanks again for taking time out of your busy schedules to be with us this morning. Before I introduce our speakers, I'd like to cover just a couple of housekeeping and logistical items. First, today's webinar is being recorded, and you'll be provided a link via email to the recording to share with your colleagues and teams. This email will also include a copy of today's PowerPoint presentation. Second, we have allotted time at the end for questions, so please use the chat feature to submit your questions, and we'll do our very best to address your questions at the end of today's presentation. And finally, it's important to note that today's presentation is considered a general source of information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting with your legal counsel. Okay, so with with our housekeeping items aside and our legal disclaimer put to bed, I'd now like to introduce our presenters and thank both of them in advance for being with us today. Kevin West is a shareholder in the firm's Boise office and the chairperson of our firm's healthcare department. He focuses his practice on healthcare law involving audits, investigations, medical malpractice, and licensure board disciplinary matters. Andrew Alder is also a shareholder in the firm's Boise office. His litigation practice focuses specifically on healthcare law, representing medical providers in a variety of medical malpractice lawsuits. So with that, I'm going to turn the time over to my colleague, Kevin West, who will kick off today's presentation. Kevin, Andrew, welcome. Thanks again for being with us today.
All right. Thank you very much, Jason, and good morning to everyone. Thank you again for joining us in this continuing series. So just by way of an introduction, I've shared this little drawing many times with people. I think it's a great lesson for healthcare providers. This is obviously a crayon drawing by a young woman, a young child actually. She's depicting herself in a doctor's office. You can see her in the middle with the braids sitting on the exam table. And the most interesting part of the picture is the figure on the far left side, who is her doctor, who is sitting with his back to her, typing away at his computer. So just a little bit of a thought-provoking sign of the times, unfortunately. So about 20 years ago, I was asked to be part of the Idaho HIPAA Coordinating Council. It was set up by the Idaho Medical Association to travel around the state in sort of a roadshow fashion, giving presentations to healthcare providers about this strange new law that everyone was talking about called HIPAA. And since that time, 20 years ago, I've had the privilege of working with hundreds of healthcare providers on compliance, preparing policies and procedures, training their staff, and more recently in defending healthcare providers who have been audited or investigated for HIPAA violations. So I thought this morning it might be helpful to share some things that we've learned during those 20 years and to talk about a few lessons for going forward. Maybe from a big picture perspective, it's always important to recognize that any violation of patient confidentiality is both an ethical and a legal violation in virtually every state in the country and can result in some very bad things happening. It can result in licensure board discipline. It can involve a lawsuit and may also involve an investigation and fines and penalties by the Office of Civil Rights, the OCR, which is the agency that enforces HIPAA. So, these are things to keep in mind. It's also important to keep in mind that the patient privacy is not unlimited. Even patient privacy bows to the public good. So when there are issues of public health and safety, or even individual health and safety, those things can often, in more rare circumstances, override. So, speaking of these 20 years, where have the problems been? The OCR keeps a running tally of their complaints, and you see the list there of some of the things that they've seen as the most common problems. Their number one item, denial of access to the patient's own records. That coincides with my own experience as being the single biggest problem area, surprisingly enough. And I've had lots and lots of cases, investigations, audits, and complaints relating to that particular issue. Item 4, sending PHI to the wrong place, either faxing or mailing, has been an issue. And then number 5, allowing access to unauthorized persons, has always often been a common experience with me. Now, these are privacy issues. There's a whole other set of complaints having to do with electronic security, with laptops being lost and that kind of thing. But these are the primary privacy complaints that we've seen over the years. Some other things we've learned, let's see, there we go. Some surveys over the years have shown that, and this survey was a few years back, so I would expect the percentages to be higher, but we see, the hospitals are certainly at least claim to be more compliant than the physician practice offices, and that's probably to be expected since hospitals have dedicated personnel to this issue and most doctors do not. Interesting statistic at the bottom, about 1 in 4 healthcare providers have actually gotten a privacy complaint from a patient. Some other things we've seen, really unfortunately in my mind, there continues to be really widespread misunderstanding, lots of HIPAA mythology, lots of confusion, and that's not because healthcare providers are dumb. It's because the law is unfortunately complicated, has a lot of little nuances, and a busy practitioner often simply is not able to grapple with all the consequences of HIPAA. And that's, again, led to the continuing widespread misunderstanding on certain issues. We've seen unintended consequences. HIPAA was supposed to open up the free flow of communication and healthcare information with patients, with other healthcare providers. And unfortunately, in some situations, we've seen people pull back and become more tight-fisted about sharing health information than they were before. And again, part of the misunderstanding that people had was they thought, well, now that we've got HIPAA, we've got to be even more careful, which was true in some respects, but with respect to patients or other healthcare providers, especially treating providers, HIPAA was designed to do the opposite of that, but yet we've seen people really not follow through on that spirit of the law. So as I've taught about HIPAA, both at Boise State University as a teacher and with the many practitioners I've worked with, I've always tried to emphasize the single basic rule of privacy. And if you understand this one rule, you can build on it and understand many things. And that is, patient health information, PHI, cannot be disclosed unless one of 2 circumstances exist. Number 1, there is a valid medical release signed by the patient, or there is a specific HIPAA provision that allows you to disclose even though you don't have a release. So whenever I encounter a HIPAA situation where we've got an alleged improper disclosure, this is the very beginning I go back to time and time again. Number one, do I have a release from the patient? Is it a valid release? There are lots of releases out there, by the way, that don't meet HIPAA standards. So that's the first question. And if the answer to that is yes, it's pretty easy at that point. We can share information. If there is not a valid release, then we begin looking at the multitude of HIPAA provisions that do allow for disclosure, for example, to other treating providers, to billing services, to collection agencies, to law enforcement. I could go on with these many exceptions. But again, this is the basic rule on the screen that is more important than any other, and the rest of HIPAA really builds off this general rule. So some ongoing concerns. Social media, I'll mention a few things about that in a moment. Texting continues to be an issue. The use and loss of unencrypted laptops. And I know the minute I have a healthcare provider who has had a laptop lost with medical records on it, I know right then we are in a pretty catastrophic situation that's probably going to involve hundreds of patients and huge cost and problems in addressing that situation. We've got ransomware, which is on the rise, which Andrew's going to talk about. And then we've just got a basic failure of many practices to have operational HIPAA policies and procedures. We have a lot of practices that have very dusty HIPAA policy manuals on their shelves that haven't been looked at in 20 years. And so the failure is to have an operational policy that is actually being used in the practice. So just a few statistics. I always think these are interesting about different things. So many physicians, over 2/3, using social media in some form. 1/3 of them have admitted to receiving friend requests from patients. Doesn't say how many of those accepted the friend requests, but they got them. And then healthcare professionals who are out there blogging. So I'll be back to social media in a moment, but just a quick note on texting. And obviously, this is a problematic area. The American Hospital Association and other professional groups have taken the position that texting PHI in an unprotected environment, just sending a regular text with patient PHI, is a violation of HIPAA. And the federal government is consistent with that. And the basic reason with texting is, you know, the fact of where those texts end up residing. They end up residing in somewhat unknown places. We don't know who has control of them. We don't know who is seeing them. And then in the transmission process, you know, there is some risk of interception. So it's pretty universally held out there that texting is improper. But despite that, we see it happening really quite frequently. So let's talk a moment about social media. And the thing I always point out, you know, social media is so popular, it's so useful and helpful, but let's remember that the basic purpose of social media is in tension with the basic purpose of HIPAA privacy rule, which is to protect information. Whereas social media, the purpose is to do the opposite. It's to share information. So that's something that's just important to keep in mind. I'm certainly not saying you should not use social media. I'm just saying let's recognize that there is this tension out there. So maybe I could just offer 6 do's and don'ts about social media. First, when you're using social media, this sounds so obvious, but yet you see it happen. We cannot discuss patients in a way that might identify them. And I know doctors and their staff who like to blog, who like to post on Facebook, and they like to tell experiences they have with patients. And if that is done completely anonymously, that may not be a problem, but often from the context of these blogs or posts, you can identify a patient. Because if you start saying things like, right now I'm taking care of a young man or young woman in room 202 at St. Luke's. You've just violated privacy. You've given information that would allow someone to identify a patient. And there's many other ways of doing that besides specifically naming the patient. So great caution needs to be used whenever we start relating war stories or experiences with patients. Secondly, I really caution doctors and healthcare providers about friending patients. We all know that as professionals, we have to maintain appropriate professional boundaries with our patients. And if you are texting and Facebooking and Snapchatting and Instagramming and whatever else you're doing with patients, you run a great risk of crossing those boundaries. And I have seen numerous instances where doctors got in trouble, not only for perhaps violating privacy, but also for just crossing the boundaries, becoming too close, too intimate with patients because they are using these very informal devices. So third, being careful about testimonials and patient pictures. HIPAA does allow those, but you have to get proper consent from a patient when you're doing that. And when I say proper, it really needs to spell out how you're going to use that information, for how long, what its purpose is, and those kinds of things. All right. Fourth, this is a very, very difficult one that is an ongoing problem. And that is, you get a patient who is unhappy with you, and at the very least, they give you a bad review, or at worst, they start really trolling you and saying horrible things online about you. What can you do? And it's very frustrating, because if you go online and start rebutting and debating, you are putting yourself in a problem of potentially violating privacy. And as a professional, unfortunately, you cannot necessarily respond in kind when you have someone complain about you. And by doing that, you're going to make yourself look unprofessional. And again, you are going to potentially risk privacy now. You can sue a patient, in traditional ways if they are defaming you. There's libel and slander going on, but I would strongly discourage anyone from going online and conducting the battle online. Very bad idea. So those are the don'ts. A couple of do's. Of course, promote your practice and the services that you provide. That's why the main reason in my mind for social media is to get your name out there, your qualifications and your skills and your services. And then if you decide that you're going to have social media happening in your practice, I think you can't just go at that willy-nilly without thinking it through. I recommend you have some type of policy for yourself and your staff, limiting who speaks for the practice, guidelines about the contents of what you post, and other things about discrimination and a disciplinary policy for practice members who violate that. So that is really a quick overview and perspective regarding HIPAA after 20 years. All right, I'm going to move to a new area, and some of you may be aware, I hope you are aware, of a new federal regulation. It came as a result of the 21st Century Cures Act, and these particular rules are called information blocking rules. I am very concerned that the provider community is not yet aware of these rules. I spoke at a conference 2 weeks ago to a group of doctors. I asked them by show of hands who had heard of the information blocking rules. Not a single hand went up. That was very concerning. So this is a new regulation that took effect in the spring of this year. I believe it is still very widely unknown. So I wanted to spend maybe 15 minutes giving you the basics, which is all we can do in the time we have here about this new rule. So what is information blocking? The name is unfortunate to me. I think it should be called the anti-information blocking rules, because that's really the idea. But here's the definition. Information blocking is a practice that is likely to interfere with, prevent, materially discourage, or otherwise inhibit three things: access, exchange, or use of electronic health information. So that definition is very important. You notice that it pertains only to electronic health information, not paper. And the prohibition is against things that prevent access or exchange or use of that health information. To prove a violation against a healthcare provider, it's a pretty high bar. It has to be proven that the healthcare provider actually knew, had actual knowledge. Whereas with health IT vendors, who are also targets of this law, the bar is lower. All the government has to show with them is that they either knew or they should have known that what they were doing was information blocking. So this is the basic concept and idea of information blocking. So the rule is not unlimited. There are exceptions. There are certain times where doctors are required by law to avoid disclosure. In those somewhat rare circumstances, information blocking is not going to be a problem. And there are also there's 8 listed exceptions to the information blocking rule, and we will not have time to go through those today, but there are some exceptions to the rule. So it is important to understand a perspective as to how we get to the information blocking rule. We have, of course, HIPAA being enacted in '96. We have the final regulations taking place in 2003 and 4. And then we have the high-tech rule, which made a big change in 2009. We have the 21st Century Cures Act, which authorized HHS to develop rules on information blocking, which after a considerable time period finally took place in the spring of this year. But here's the thing to understand. HIPAA created for the first time ever a federal right of access for patients to their health information. And providers had quite a lengthy period of time to respond to requests, 30 to 60 days. There was no right to electronic access specifically in the original version of HIPAA. Then later, the HITECH Act strengthened patient rights by guaranteeing the right to obtain access in electronic format. It shortened the time periods a little bit, and it limited the fees that could be charged. But even after HIPAA and HITECH, there were really significant lapses or gaps in the ability of patients to get access. Despite HIPAA and HITECH, patients still did not have anything close to real-time access to their records. And there were still hundreds of EHR systems that did not allow free sharing of their information between platforms. So despite these rules, there were still great problems. And as a result, Congress felt that the information rules were necessary. So, information blocking has a dimension beyond just patient access, and this concept of, and it's a long word, interoperability. That's 8 syllables. That means technology platforms must speak to each other. So here's an example. A patient had been on beta blockers, which had a black box warning not to abruptly stop the medication. A provider's EHR system had a warning feature about doing that, but the charting side of the EHR and the medication portions of the EHR did not communicate with each other. And as a result, a resident stopped the medication cold turkey. The patient suffered a complication and died. This is an aspect of information blocker having to do with exchange of information. And this EHR system was not designed for that to happen as it properly should have. So that would be an example of information blocking. Another example, patient had an x-ray of their lung to rule out pneumonia at a hospital. The x-ray showed an infiltrate, and that was noted on the radiology report. But instead of sharing the report with the patient's treating doctor digitally, the radiology department of the hospital faxed the image. And again, old technology here, which was very blurred, difficult to read. Treating doctor did not learn of the findings, did not note them on the x-ray, and the patient had severe complications. Again, we have an issue with the exchange and use of this information in this situation. So I try to always relate the information blocking rule back to HIPAA and how do these laws interact together. HIPAA does not require real-time access. You know, once you see a patient and that dictation is put on your EHR, HIPAA never required you to just allow patients to see it immediately. The information blocking rule is not entirely clear on this, but it uses the language that the access should be without delay. And so that's either real time or something very close to that. And as to third parties, you know, really everyone but your patient, HIPAA usually specified what may be or might be shared. It was permissive. Whereas the information blocking rule in those situations actually mandates or requires access. So here's a good rule of thumb to understand with regard to third parties out there, other treating doctors, labs, that kind of thing. And the rule is where HIPAA permits disclosure of PHI, the information blocking rule requires it. It's a very important rule of thumb to understand. And the official comments to the information blocking regulations state, as you can see on the screen, you know, we do not require the disclosure of electronic health information in any way that would not already be permitted under the HIPAA privacy rule. However, if an actor is permitted to provide access under HIPAA, then the information blocking rule would require the actor to provide access so long as the actor is not prohibited by law from doing so. So we've got this very important dichotomy to observe between HIPAA and the information blocking rule. So an example of that, you're a specialist and the patient's primary care doctor asked to see a copy of your treatment records. Under HIPAA, under old rules, you were not required to provide the records. Medical ethics may have dictated that you do so, but it was, again, HIPAA was permissive in that respect. Under the information blocking rule, however, your records must be accessible and must be given, you must give access to the primary care doctor. And you cannot put up roadblocks like demanding a medical release from the patient. And I think that this is going to be one of the last doctor's offices to die a slow death, is this requirement of requiring medical releases from one treating doctor to another. It should not have been happening really under HIPAA, and under the information blocking rule, doing that can actually be a violation of the law. So important example to understand. Another example, really in dealing with third parties, say you have a billing service or an EHR vendor who refuses to grant access to you to your medical records when your contract ends with them. You know, HIPAA was not really strong about addressing this particular issue, but the information blocking rule absolutely prohibits that. And I've had an incident recently with a client, a doctor's office, who was in this situation. And when they reminded the EHR vendor about the information blocking rule, the EHR vendor actually backed down and allowed them to have that access. So that's a good aspect of this rule, is it gives you as providers some additional leverage you may not have had before. So what are some practices that may constitute information blocking? Contract terms like we just talked about with electronic software vendors that restrict access or restrict the exchange of electronic health information. Those types of contractual provisions are no longer appropriate. Or likewise, charging prices or fees that make access cost prohibitive, or implementing IT in non-standard ways that make it more expensive or difficult for others to access, or developing policies or contracts that lock a user in and makes it very difficult or expensive for them to change. These are all practices that the federal government now condemns as information blocking. So some other comparisons to be aware of. One is charging for access. With HIPAA, patients could be charged a cost-based fee for paper or electronic records. With everyone else, the healthcare provider could charge whatever they wanted. Now, under the information blocking rule, patients cannot be charged for access to electronic information or to export data to them. You can still charge for paper copies, but you cannot charge for electronic access. With all others, third parties, you can charge them, but it has to be a reasonable cost-based amount. So I'm going to move past this slide, and you may be sitting there saying, you know, what does this information blocking rule require me to do? What do I need to do? And I would really say a couple of basic things in terms of making technical and operational changes. From a technical standpoint, you really need to have a conversation with your IT people, your EHR vendors, and directly one-on-one ask them if their software meets the requirements, and ask if they are familiar with the information blocking rule. If they tell you they are not familiar with the rule, I would suggest you've got a significant problem, and that problem needs to be addressed and resolved. There is a way to look online. I haven't gone to this website personally, but other resources have said there is a way to check to see if your software is certified to comply. But again, that doesn't really alleviate the need to actually communicate with your vendor about this important issue. From an operational side, and I'm doing this with many practices right now with many of my clients, we are revising their HIPAA manuals. We're revising their notice of privacy practices, their business associate agreements, some of their policies, and we are encouraging them to get training for their staff. These are all things that are not huge tasks, but do need to be accomplished. So what information is subject to this rule? Well, you see the list. Up to April 5th, there's a list of 8 different types of records, which frankly are the majority of what most providers keep anyway. And after October 5th, 2022, it will be really anything that constitutes electronic health information. So it will be broader than just the 8 categories of notes or records that you see on the screen. So they are rolling this out in stages, as you can see there. But, you know, in my mind, I would just urge providers to be in a position where they are complying with any electronic health information they have at the time. Who enforces these laws? Well, for HIPAA, it's the Office of Civil Rights, and there is a potential for civil monetary penalties. For information blocking, it depends on who's involved. For health IT, it's the Inspector General, the OIG. For healthcare providers, it will be CMS that is doing the enforcing of information blocking. Health IT companies really have a big target on their back with this law. They can be fined up to $1 million for engaging in practices that constitute information blocking. That's very serious money. With providers right now, they have not come out with enforcement rules yet. All the rule currently says that they will be referred to an appropriate agency for appropriate disincentives. And I really love the bureaucratic speak here, which no one knows what that really means, but it doesn't sound good regardless. So let me just conclude in my last 2 minutes with a quick side-by-side comparison of HIPAA versus information blocking. As we said earlier, HIPAA is permissive. It says when information may be shared. Information blocking says in those situations sharing is mandated. We talked about earlier in terms of access, HIPAA grants the right to access to patients, and information blocking mandates that for certain types of records, and then all records after October of 2022. Continuing on, in terms of the time, providers under HIPAA had 30 days. Now access must be really made available, if not real time, then at least without delay, which would suggest a very short time period. There are exceptions to providing access under both HIPAA and information blocking, which we really don't have time to go through in detail here. Under HIPAA, access must be allowed in the form requested by the patient, whether it's paper or electronic. With information blocking, it really applies only to electronic records, and it's got to be allowed in a way that does not impose unreasonable barriers. Then in terms of fees, we've really already covered this earlier about what can be charged under the two different rules. HIPAA defines who may have access, and again, information blocking really piggybacks on HIPAA on who has access under the rule and mandates that access be allowed. HIPAA talks about use of medical releases. Information blocking really doesn't address that, but simply says if access is allowed under HIPAA to third parties, that the information blocking rule will require that. Okay, this is sort of a technical change. I won't necessarily go into that. HIPAA has a security rule component where you must implement certain practices, firewalls, encryption, those kind of things. And the information blocking rule does not contradict that. It simply says whatever security measures you put in place cannot unreasonably block access. So that was a very whirlwind tour through HIPAA and information blocking. It's a challenging new area to grapple with, but one that providers need to do. And with that, I'm now going to turn the time to Andrew to talk about HIPAA audits and enforcement.
Thanks, Kevin, and hello, everybody. Thanks for joining us this morning. I'm going to cover a couple of topics. First, HIPAA audits and enforcement, and then I'm going to talk about some cybersecurity issues and issues related to HIPAA's security rule. I want to stress that this is really just an overview of the fundamentals and sort of to talk about some of the trends that we're seeing in these areas. We could talk about these topics for hours, so this is not meant to be a deep dive on these topics, but would be happy to provide additional information if people have questions or want to contact us after this presentation. I see that there's a number of questions already, and so we want to leave some time for questions at the end. So this will just be an overview about some of the fundamentals here. So regarding HIPAA audits and enforcement, I'm going to make sure that I can move my slides here. There we go. So just some basics about HIPAA enforcement. The Office for Civil Rights, OCR, is the agency that enforces HIPAA. And they like to say that they enforce, that their enforcement process includes sort of three different things. First, investigating complaints. Second, conducting compliance reviews. And third, performing education and outreach to foster compliance. There's kind of the complaint process is a bit complicated, and complaints can go in a number of different directions. This is a nice little decision tree here that shows you what happens when a complaint is filed and the different directions it can go. It can be resolved at the outset if OCR immediately determines that either they don't have jurisdiction or there's clearly no HIPAA violation, it will be resolved without even an investigation, and you may not even become aware of the complaint. If there's a possible HIPAA rule violation, then it will go through either sort of a quick, immediate resolution process where OCR reaches out to the provider and provides some technical assistance, and determines not to do a full-blown investigation. Or there can be a full-blown investigation, and then there's various resolutions that can come from that. Keep in mind that when there's a complaint and OCR determines that they need to conduct an investigation, oftentimes that investigation is pretty wide-ranging, and they can ask for a lot of information and really dig into your policies and procedures and the way in which you are complying with or not complying with HIPAA, and it can go beyond just that one patient complaint. So it's something to be aware of, and it's obviously a good idea if you learn that there's an investigation to reach out to counsel to help you through that process. Other compliance reviews and audits. So OCR will initiate a compliance review if there's a complaint. They can also initiate reviews based on media reports, based on referrals from other state and federal agencies, and also based on trends in complaints that they are seeing across the industry. And we'll talk about some of those in just a moment. So in 2016-2017, OCR conducted a random review of selected healthcare entities and business associates for compliance of HIPAA. It wasn't actually until December of 2020 that they issued their report and their findings based on that randomized review. But there were a number of conclusions that are somewhat concerning and providers should be aware of. So that report concluded that most covered entities, most providers and covered entities, failed to provide all of the required content for a notice of privacy practices. They failed to provide all of the required content for breach notification to individuals. They failed to properly implement the individual right of access requirements, which we'll talk about in a moment. And they failed to implement the HIPAA security rule requirements for risk analysis and risk management. The OCR Director said this following the report. He said, "The audit results confirm the wisdom of OCR's increased enforcement focus on hacking and OCR's right of access initiative. We will continue our HIPAA enforcement initiatives until healthcare entities get serious about identifying security risks to health information in their custody and fulfilling their duty to provide patients with timely and reasonable cost-based access to their medical records." So this quote, I think, encapsulates and is a pretty good indication of where OCR's focus is right now, which is on hacking and cybersecurity issues, as well as patients' right of access. So what's the current climate with HIPAA enforcement? Complaints and OCR enforcement activities have increased significantly over the past several years. You can see there the number of complaints has been increasing. It dipped a little bit in 2020, but still is much higher. There are more complaints than there have been in the past. Compliance issues that are most often alleged in complaints concern impermissible uses and disclosures of PHI, lack of safeguards of PHI, lack of patient access to PHI, lack of administrative safeguards of electronic PHI, and the use or disclosure of more than the minimum necessary PHI. So again, a couple of focus areas for the OCR. In 2019, they launched the Right of Access initiative. The purpose of this, in OCR's language, was to enforce patients' right of access to their own health information in a timely, reasonable manner. This is not a new concept or a new rule, but it was a new focus of enforcement. Since 2019, since that initiative began, there have been 20 settlements reached between OCR and covered entities related to violation of the right of access. The penalties range from $3,500 to $200,000, and we're seeing more and more of these even within the last year. And bear in mind, this right of access initiative began even before the information blocking rule that went into effect last year that Kevin talked about. So this is clearly a huge focus and will continue to be a huge focus of enforcement. Additionally, it's increasingly common to see HIPAA violations for an entity's failure to perform adequate security risk analysis. And these are typically violations that have resulted in quite large settlements or large penalties. We're going to kind of talk more about this, and this topic dovetails neatly into the final thing that we'll talk about today, which is cybersecurity and HIPAA's privacy or security rule. So cybersecurity, this is a major concern that we are seeing in the industry right now. And this relates to HIPAA's security rule. So I want to just talk very briefly about the basics of the security rule. So there's essentially 4 things that covered entities are required to do under the security rule. First, ensure the confidentiality, integrity, and availability of electronic PHI. Number 2, identify and protect against reasonably anticipated threats to the security or integrity of the electronic protected health information. Number 3, protect against reasonably anticipated impermissible uses or disclosures of electronic protected health information, and ensure compliance by their workforce. The security rule is meant to be flexible and scalable, so it requires covered entities to consider their size, complexity, capabilities. So obviously what a small practice does to comply with the security rule may be different than what a large hospital or other large entity needs to do. The cost of the security measures can be taken into consideration, and the entity's technical hardware and software infrastructure. It's important too to remember that data breaches are now a fact of life, and we're going to talk about that in a minute. So even with appropriate cybersecurity defenses, data breaches are still likely to occur. So being HIPAA compliant is more about reducing risk to an appropriate and acceptable level, as opposed to a bulletproof system that would never be attacked. So one of the most fundamental things that's required under the security rule is a risk analysis. That's defined as an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, and availability of electronic protected health information held by the covered entity or business associate. OCR has put out some guidance on that. It includes 9 elements of a risk analysis that must be incorporated. A couple of important things to remember: that it should be documented, right? So if you're investigated and you simply tell OCR that you had done this risk analysis, but there's no documented proof of that, it's going to be more difficult to overcome that barrier. So it needs to be documented. It also needs to occur regularly. We recommend as a standard at least annually, and it needs to be modified in our changing environment. And then the risk management plan that your entity develops must include 3 types of security safeguards. Administrative safeguards, which is the policies and procedures that are designed to clearly show how your entity will comply with the security rule. Number 2, physical safeguards, which is controlling physical access to protect against inappropriate access to protected data. And then number 3, technical safeguards, which is controlling access to computer systems and protecting your electronic communications. For each type of security safeguard, the rule identifies various security standards that need to be complied with. So a couple of real-world examples of issues involving the security rule and OCR enforcement. So the first one is the University of Rochester Medical Center. There was a violation for impermissibly disclosing protected data through the loss of an unencrypted flash drive and also theft of an unencrypted laptop. It resulted in a $3 million settlement with OCR. And OCR's investigation found that URMC failed to conduct an enterprise-wide risk analysis. They failed to implement security measures to sufficiently reduce risks and vulnerabilities, and failed to utilize device and media controls, and failed to employ a mechanism to encrypt and decrypt electronic PHI. The second one is the University of Texas MD Anderson Cancer Center. There was a $4.3 million civil monetary penalty based on, again, a stolen unencrypted laptop and loss of 2 unencrypted USB thumb drives. Now, a bit of good news here, a federal court of appeals vacated that penalty in what truly is a rare rebuke of OCR's enforcement power. And they found, ruled a couple of interesting and important things. So first, the encryption rule they found requires only that the covered entity have a mechanism for encryption. And because they had a mechanism for encryption, there was no violation. Second, a covered entity does not violate the disclosure rule anytime it merely loses control of electronic PHI. A violation requires an affirmative act of disclosure, not a passive loss of information. So there's, I think, 2 takeaways from these examples. First, I think if these 2 entities had encrypted the laptops and the flash drives that were lost or stolen, it likely would have decreased or altogether avoided those settlements and those monetary fines. And then the second takeaway is that in both cases, it was not necessarily that the electronic PHI was stolen or lost, but rather whether the entities had implemented the required policies and procedures. So briefly, and I'll cover this in just a couple of minutes so we can get to questions. A current cybersecurity concern that we are seeing is ransomware attacks. Ransomware attacks, you probably know generally what they are, but essentially it's when malicious software is used by hackers to lock up your system, lock up the data that's stored on your computer or other electronic devices, and it renders that data unusable. Typically, hackers will demand a ransom payment in exchange for getting your data back, and usually they'll pay or they will release your data once you've paid that, because there needs to be an incentive for people to make those payments. It often happens when victims mistakenly download malware through email attachments or links from unknown sources. I'll skip through. There's just a number of headlines that I've included on a few slides about large ransomware attacks. You've probably seen these as you've read the news as well. An interesting statistic from experts in 2021, experts say that 850 healthcare networks and hospitals were affected by ransomware. And it's truly a multi-billion-dollar industry. This is the new normal. These headlines and these attacks are just the tip of the iceberg. Keep in mind that you are at risk, and if you're not prepared for the downtime, your patients and your practice will suffer. There was a recent lawsuit that was filed alleging that a baby that died during birth was the result of a ransomware attack on the hospital, which the allegations are that ransomware attack resulted in diminished care for that baby because the hospital didn't have access to the family's medical records. So now is the time to start preparing for that. Providers should have a downtime contingency plan. This requires doctors to plan for things that they can anticipate happening if they're hit with a ransomware attack. Doctors need to do their best to continue to serve patients even when they don't have access to their computer systems. And part of that is to have a good backup system to work with your IT folks and your whatever entity controls your electronic health records to make sure that your records and your computer systems are backed up. Business associate agreements are also important. You need to have a business associate agreement with everybody you share data with, and that agreement should include provisions regarding communication with you when there's a problem. And the agreement should also require the business associate to treat your data with proper security to protect your data. More information about uptime guarantees and what guarantees your business associates can provide related to their systems and the data that they're going to be receiving from you. Insurance is important in this regard, both your own insurance and the insurance of your business associate. You need to know if they have insurance, if they have cybersecurity insurance, if they're going to cover any losses that occur if they're hit with if they're hit with a ransomware attack. Again, yeah, there's other kinds of insurance that your business associates should have and also that you should have. I'll skip through these last slides, but you can review these later related to additional information you should receive and have with your business associates. We only have a few minutes left, so I want to leave some time for questions, and Jason, I'll let you take it from here.
Great, Andrew, thank you very much, and Kevin, great job. Thanks to both of you for the wealth of information today. Let's go back to the topic of social media for just a moment. Kevin, I'll put this question in your court. Does the quote, "don't friend patients," apply to all staff or only the provider? What would you recommend there?
Yeah, I think the biggest concern is with the provider because they're the ones who have the ethical and professional obligations, not staff. So I'm not as concerned with staff doing it as long as they don't share inappropriately or do not speak on behalf of the practice. If they're just outside the office, friends with the patient, I guess I don't have a huge red flag about that.
Okay, along the same lines, and let's keep this in the context of the provider and not staff. If a provider receives a nice review online, is it okay to comment with a message of gratitude? So, for example, by saying "thank you, we appreciate your business."
Yeah, I don't have a problem with that.
Okay, great. Thank you very much. There was a question concerning texting, and a couple of questions related to this topic. Is texting appointment reminders permissible?
The answer to that is yes, it is.
Okay.
If that's all that's being done is a reminder of the appointment with no PHI included in the text, that is acceptable.
Okay. And related to texting also, is texting with the patient, assuming you have consent, permissible? And I think that would probably, be based upon the type of information that you're sharing. But is it permissible to text information to a patient with his or her consent?
The problem with doing that is it's still being done in an unsecure environment. So I would still say is something I would discourage providers from doing. You know, if it's very minor, like the patient texts and says, what time is my appointment today? Or do you have my lab results? I would just text back and say, yes, give me a call or something like that, and try to minimize the texting that happens. So even if the patient consents, it's still not considered secure.
Okay, thank you. So best practice there is to minimize information transferred via text.
Correct.
Okay. One final question, and this is related to EMR. Is a paper document that is scanned into a patient's EMR now considered electronic health information?
Yes, yes, it is.
Okay. Well, those were all of the questions that came through via, oh, looks like we've got another question that just popped in. Andrew, why don't you take this one? Is there a risk analysis checklist available online?
So there is. OCR has put out a guideline on risk analysis, and there's actually a link to it on that slide in the PowerPoint, Jason. But if the questioner is having a hard time finding that, I'd be happy to send it to him.
Great. Andrew, thank you very much. Well, in the interest of everyone's time, we'd like to be prompt and stop at the top of the hour, in this case, the bottom half of the hour. But I want to extend a big thanks to all of you for joining us for today's HIPAA Privacy and Security webinar. I'd like to thank Kevin West and Andrew Alder for preparing today's presentation and for all the information that you shared. And for those of you that joined late, I wanted to remind you that you will receive a copy of today's PowerPoint presentation along with a link to the recording of the webinar. And finally, our next webinar is scheduled for Wednesday, February 16th from 8:30 to 9:30 a.m. And this will focus on licensing and privileging. Keep your eyes peeled. We will be sending out an invitation for this event in the coming days. And in the meantime, we wish all of you the very best, and thanks again for joining us for today's webinar. We'll see you soon.